the property management industry, fair housing offenses are considered especially troubling. In the United States, a dedicated fair housing attorney, Leslie Tucker, provides case explanations and best practices. These are some cases.
Hello, everyone, and welcome to the Fair Housing Insiders Case Files, Episode 16 with Leslie Tucker, the principal at Williams, Edelstein, and Tucker. I am your host, Jonathan Sarr. In this case, we have not one, but three nonprofit cooperative corporations that find themselves in the violation of the Fair Housing Act based on their community policy in regard to children. Leslie, can you please share a few facts regarding the case as well as the outcome up to now?
Sure. So the defendants in this case are corporations, as you said, that own several multifamily buildings on an island in Florida. Each of the three buildings have governing documents that include a clause that prohibits any child under the age of 12 from residing in the unit. The Department of Justice conducted multiple tests at these properties, and the testers were told each time that they could not rent there because they had a child under the age of 12. One of the buildings in question advertises itself as an adult community, and one of the buildings describes itself as a senior or 55-plus community. The Department of Justice alleges that neither building meets this standard. Because of the clause that requires children to be of a certain age in order to live there, this case was brought under familial status, among some other causes of action as well. The defendants ended up settling this case, which included a requirement that they remove the child prohibition from its rental criteria, and all three defendants were required to pay, in total, $47,000 in damages. But this case has been resolved after that settlement.
Okay, thank you for that explanation of the case. So, question for you. Do all properties have to permit children?
Actually, no. There are some properties that are exempt from familial status requirements. And that means that they can prohibit children altogether, or they can create rules regarding the age of children occupants. The law that allows some properties to do this is called HOPA, Housing for Older Persons Act. However, and this is a big however, in order to qualify under HOPA, the housing community must meet several very specific criteria regarding its resident population, its marketing and advertising practices, and monitoring practices. And, they're not always the easiest criteria to meet. Be aware that it is not safe to assume that your property falls under HOPA and then can therefore prohibit children unless you consult with an attorney or an expert to make sure that you meet all of these established criteria. The penalties for discriminating against families with children can be quite steep, as this case shows, even if, the company mistakenly believes that the community falls under HOPA. So don't make that mistake and kind of assume that, you fall under that category unless you have been told by some sort of expert or attorney that you do.
Got it. Very good. Thank you. So let's get a little bit granular then. So if a property is federally subsidized and you must be 62 or older in order to reside there, does that property fall under HOPA? And can those properties prohibit children as well?
No. Federally subsidized housing does not fall under HOPA. regardless of if it's, an all elderly property, if you have to be elderly in order to live there, if it's federally subsidized, you are not permitted to prohibit children, just across the board. So in order to qualify under HOPA, there can be no federal funds involved with the property.
Got it. All right. Thank you again. Appreciate your insights, Leslie, on this particular case. And we thank everyone for tuning into our show. This has been episode 16 of the Fair Housing Insiders Case Files. Until next time, take care, everyone.